Good evening and welcome everybody to Vesta Divorce, where tonight we're going to be talking about legal strategies and considerations for your divorce. And at Vesta, our mission is to provide education, connection, and support to help you navigate the divorce process with clarity and confidence. And we celebrated 13 years in existence this year. So we're happy to be here. We are the three people started Vesta for us with the hope that we can help others better navigate their situation. Most of us have been through our own divorces, and having some clarity and some help during this process, we hope will be a benefit to you. Each of the professionals here tonight we all have our own background that we come from. And we will speak on tonight's topic as it pertains to our professions. We volunteer our time here at Vesta. We all have our own individual businesses, just so you understand how Vesta works. The next slide just has some legal information, legal disclaimers. This information tonight is meant as not as legal advice, but some education to help you in this process. Just wanted to make sure to mention that. The legal aspect of things is going to be based on New Hampshire law tonight, even though you may be in another state. Some of the other professionals tonight can work in multiple states, but just know that the legal side of things will be geared towards New Hampshire. And with that, we're going to start with just some brief introductions from each of the panelists. My name is Renee Coleman. I am a residential mortgage lender and a certified divorce lender. I am also the owner of Divorce Mortgage Planning of New England. And we help our clients understand their options during the divorce process as it pertains to your mortgage. I've been with Vesta for about 5 years now and happy to be here, and hopefully I get some good information tonight. I'm going to pass it over to Kate.
Hi, everyone. I'm Kate Blake. I am a family law attorney. I'm licensed in Massachusetts and New Hampshire. But as Renee mentioned, we are in the New Hampshire hub today. So when we talk about specific things related to the law, substantively, that's really going to relate to New Hampshire. If you're visiting us from another state, some of the process options that we talk about, that's more general from state to state. If you have specific legal questions about your matter and you're not actually in New Hampshire, feel free to reach out to concierge and they can connect you with an attorney in your jurisdiction. My practice encompasses out-of-court resolution, helping people through the mediation process, the collaborative law process, direct attorney negotiation, as well as litigation. And I think I've been with Vesta since it was before the pandemic, so 2019. It's been a while, but I'm happy to be here. And please feel free to use the Q&A to ask any questions that you might have.
Thanks. And
good evening, everyone. I'm Barb Shigog. I am the financial side of the panelists today. So we will, in my division, talk a little bit about the asset division, the debt division, and how an equitable settlement is achieved.
Thanks, Barb. And Lori.
My name is Lori Barron. I am also a family law attorney. I'm licensed in New Hampshire, Connecticut, and Massachusetts. I practice in all 3 states. My practice is focused on divorce mediation and collaborative law. So my practice areas are out of court. I help individuals resolve conflicts and come to a resolution in their divorce outside of court. Now, that doesn't mean that in the end, they don't have to go to court to have it finalized, but all of the issues are dealt with outside of court. I also do estate planning, and that's particularly important post-divorce, especially if there are significant assets. Even if there aren't significant assets, you still need it. But if there are significant assets, if there's a business, if there's a child with special needs, whether that child is a minor or an adult child, because at that point there's 2 separate households, and each party, each person has to plan how their assets are going to be used to take care of the things that they need for their protection and peace of mind. That's what I do. I am new to Vesta, but I have been practicing for approximately 11 years. So I'm happy to be here. And if you have any questions regarding the mediation process or the collaborative process, please let me know.
Excellent. Thanks, Lori, and we're happy to have you with us.
Hi, everybody. My name is Mandy Pullen-Barr. I'm so glad that you could join us this evening. I am a part of the concierge team. We are a team of 5 women who have all navigated their own divorce. I can't believe that it's been 18 years since mine. And it's true, life is good on the other side. And I have a very healthy co-parenting relationship, but it did not start out that way. It required a lot of support and effort from a variety of different Vesta professionals that helped me navigate my life after divorce, because Vesta wasn't in existence quite yet when I was going through my divorce. As my role in the concierge, we call everyone that is registered for the session, and we really just try to get to know you and your unique situation. And we try to build you a roadmap to get you to your beyond, whether that be work with the entire team that you see here or work with specific individuals. We cater the plan for you and your needs. And it is a complimentary service, so it doesn't cost you anything to have a conversation. We like to think of ourselves as big sisters that have already gone through it. So we look forward to speaking with you soon, and you're going to hear a really great presentation from some excellent professionals tonight. Thank you.
Thank you, Mandy. And next up, we have Michelle. She's going to introduce herself, and she's going to kick off our presentation tonight. Michelle.
Good evening, everybody. I'm Michelle Papandrea. I am a certified divorce coach. I work with men and women, supporting them pre, during, and post-divorce. A divorce coach is your thinking partner, sounding board to help you make the best decisions for you and your family. I help provide you with clarity and confidence. Divorce involves legal, financial, and emotional aspects. As a coach, I support you through all aspects of the process, but generally focusing a little bit more on the emotional pieces and helping you look at all of your options. Together, we set goals for your present and your future. We talk about how to communicate with your soon-to-be ex and prepare you to work with your lawyer or mediator. I'm also here to help you, provide you with all the resources that you might need. So today, we're going to talk about the legal considerations during and after divorce, and I'm going to focus a little bit more on the emotional aspect of divorce. So divorce involves feeling grief, anger, fear, anxiety, depression, shame, and guilt. Maybe you feel one, maybe you feel all. These feelings come and go, and some days they can be like a roller coaster, just a wave. It just comes sometimes at the weirdest moments. But it's important to acknowledge and allow yourself to feel that range of emotions that arise. But those heightened emotions can lead to making reactive decisions. So when you feel the emotions coming on, you're in the middle of a conversation or talking to your lawyer or mediation or whatever it might be, take a pause before you react. Maybe take a breath, count to 10. I usually recommend certain conversations with your soon-to-be ex-spouse that you can even take a time out from the conversation, saying, let's just take a pause. Let's come back to this at a later time. Just know that you don't have to make decisions in the moment. You can take your time. You can walk away and process what you heard, talk to your resources, and just literally just take the time to process it. Staying calm allows you to think clearly, to work collaboratively, and to make sure that your decisions are in line with your goals. You want to avoid making long-term decisions based on the short-term emotions you're feeling right now. Be self-aware, identify and name your emotions. Again, allow yourself to feel and sit with those emotions that you're feeling. It's okay to be sad. Divorce is a loss of the life you've had planned. Keep communication brief, informative, friendly, and firm. That's the BIFF method. That's the acronym BIFF. So stick to the facts. Leave out name calling or blaming. Know that you don't have to answer every text or every phone call in the moment. Take your time again. Take that breath, take a pause, and think about it. Not everything needs a response in the moment. So part of the divorce process is also creating new boundaries between you and your soon-to-be ex-spouse. You don't have the same level of access to each other. Again, going back to that, not everything needs a response and not everything needs a response right now. So creating new boundaries will help you with your communication with your soon-to-be ex-spouse when you should be answering certain things. And even communications back can simply be stating we can review with our mediator next week. That's a valid response. It follows the BIF method. Remember to practice self-care, whether it's breathing, meditation, grounding exercises. Focus on calm phrases like, I can handle this, I got this. Journaling helps some people. Exercise, walking, taking a yoga class, a kickboxing class, meeting up with friends. Do things you always wanted to do that maybe you never got to do, or maybe things you gave up during your marriage. Finally, create a team around you of people who can support you. This can be family, friends, and certainly resources on this call. Again, I'm Michelle Papandri. I'm a certified divorce coach. And next up are Lori and Kate to talk about the legal process.
Thanks, Michelle. So what Lori and I wanted to start with was to talk about the divorce process and process options. And as I mentioned, a component of my practice is litigation. So I just want to briefly describe what that means. Litigation is somebody actually filing a petition for divorce in the court system. And in New Hampshire, we have both divorce as well as legal separation. So starting that divorce process is the filing of that petition. And then that petition needs to be served on the other party. Once the court knows that both parties have been notified of the filing, they will send out a notice for a first appearance, which is for you and your spouse to be educated about the court process in New Hampshire. And part of that, and you will go with your spouse along with other people who have recently filed. Part of that first appearance is for them to explain mediation, which Lori will get into in a little bit. And then they'll encourage people to do mediation either through the court system or to do private mediation. And then after that, whether you go to mediation or you decide not to, usually the next event is a temporary orders hearing, sometimes called a structuring conference. So that is where you can get orders of support on a temporary basis. Child support, alimony, we'll get into what those words mean in a little bit. Parenting, if there's a reason that somebody might need a domestic violence order of protection, that can also be done at the outset. And Michelle gives a wonderful presentation about the emotions, and Lori and I are very mindful that emotions continue to be processed, and that's why it's really important to be working with somebody like Michelle who can help you with those emotions, because I'm an attorney. I am not a mental health provider. I'm not a coach. And often I find that people who don't work with coaches, they end up having a higher attorney's fees because they often tell me things that they've told me before. They're not organized. They're still letting the emotion drive that process. So I think it's always important to be working with a therapist or a coach or even both. So when the petition is filed with the court and when it's served on the other party, there is something called an anti-hypothecation order. That essentially tells both of you that you need to basically maintain the status quo while you're going through divorce with respect to things like health insurance, life insurance policies, retirement accounts. You can't change any of those beneficiary designations. You can't cash out a retirement account and give it to a friend and say, hold on to this while I'm going through divorce. You have to maintain everything as is. The other side has been served with that petition. They need to file an appearance within 15 days and then an answer within 30 days after that. If no appearance is filed, then the court will assume that you are in agreement or that you don't want to participate in that divorce action. And if there is no appearance or answer after a period of time, you may want to speak with your attorney about whether or not there should be a request for default judgment in New Hampshire. Also, when you file for divorce in New Hampshire, you are required to exchange some mandatory discovery. We call this Rule 1.25a, which outlines the documents that you need to exchange within 45 days. There are things like tax returns and bank statements and pay stubs and credit card statements, as well as a financial affidavit. The financial affidavit is a very important document that It needs to be used no matter what choice you are in because it is required by the court. That financial affidavit lists your income, your assets, your liabilities, your expenses. It also has some other information that needs to be included in that. I always recommend that people begin working on that document very early on in the case because it can be very overwhelming and daunting. And if it becomes almost paralyzing, I often recommend people work with someone like Barb, who's a CDFA, has a lot of familiarity with that. Financial affidavit can help you with that. And these disclosures in that financial affidavit are important because that helps us with the division of assets. Beyond that mandatory discovery, when you have a litigated case, there are additional requests that you can make. These include interrogatories, which are written questions that somebody has to answer under oath. You can ask for documents that exceed what is required by the Rule 1.25a. So, for instance, the 1.25a requires documents for 6 or 12 months, depending upon what type of document. You could ask for documents that are more historical than that. You could go back 3 years, couple of years, whatever you think you might need. You also have the ability to subpoena documents from third parties, like a credit card company or a bank company, if your spouse is not being forthcoming. Sometimes it's just easier to go directly to the source. Formal discovery that I've described is due within 30 days of it being received. And if someone does not respond after a period of time, you can also seek to compel that, and you can also seek to have default entered on those requests. I think at this point, I'm going to go back to our original slide. I think I'm going the wrong direction so that Lori can talk about some of the out-of-court processes.
Thank you. Thank you, Kate. Yes. So what I'm going to talk about now is first, I'm going to start off with mediation. So mediation it's not representation. Mediation, the parties come in, they meet with a third party neutral who helps facilitate the conversation between the parties. So whatever issues there are, the parties are, each spouse, they're working it out with each other, being guided by the mediator. The mediator does not give advice. However, the mediator knows what the court is looking for in the ultimate separation agreement and what areas have to be addressed. And a lot of times, mediators are not attorneys, but a lot of times, just as much, they are attorneys. So when you have an attorney mediator, they're not giving legal advice and they're not representing anyone, but they do have experience in the court and they know how specific judges in that specific area work. And so they help guide the conversation and guide the process, knowing in the end what is going to be needed for an acceptable agreement. Now, when anyone goes to court for a divorce, the judge is going to make rulings on the separation agreement to determine if it's acceptable under that state's current law. But that doesn't mean that the parties can't come up with an agreement that works for them, as long as it falls within that, under that umbrella of what's acceptable. So mediation offers a way for the parties to be creative and to come to an agreement that works for them without having somebody else decide that. And as I said, the mediator helps guide that conversation in terms of what would be acceptable, what wouldn't be acceptable. But ultimately, the parties come to that agreement and it's presented to the court. In terms of mediation, it's very helpful if these support professionals are involved in that as well, not directly during the mediation, but on the outside. It's recommended to have a CDFA or a divorce coach to help with the emotions. So when the parties do come to the table, they can have an easier conversation because the emotions have been addressed. Doesn't mean that emotions don't come up, but it just helps facilitate the conversation. The thing about mediation is that it's on your timeline. You're not working within the court's time frame. As Kate had mentioned, there's a 30-day deadline here, there's a 45-day deadline there. So with mediation, you're not doing that. You're simply coming to the table and working out the issues on your own timeline. Now, with that being said, both parties have to voluntarily be there. They have to voluntarily want to work work things out as amicably as possible, which means that they agree to provide that discovery that Kate had spoken about. Because without that discovery, without that information, there can't be an effective conversation to address the issues that the court would need to address. With that being said, mediation is great if both parties are willing and to do it, and they want to try to avoid unnecessary court costs and court time, because the litigation process can take an emotional toll on people already going through a very difficult time. Now, with that being said, sometimes mediation does not always work out in the end. And so you're not giving up your right to litigation by starting off with mediation. It's a tool to use to help make the process easier, but you always have that remedy in court if things can't be taken care of during mediation. Now, it's the same with collaborative law as well. Collaborative law is very similar to mediation, except that with that method, you are represented by attorneys. So your attorney and the other party's attorney sit down and basically do the same thing, except during that type of alternative dispute resolution type of thing, you have representation. So you have an advocate there with you. Sometimes that's necessary if there's a lot of contested issues that needs someone in your corner at the table, but might not necessarily need to be litigated. With collaborative law, it's the same thing. Both parties have to be willing to do it. The supports are there, the CDFAs, the coaches. The caveat with that is that if you have a collaborative attorney with you, and it does happen to go to litigation because things can't be worked out, that attorney cannot represent you in that litigation. At that point, you would have to get a new attorney. But just like with mediation, you always have that remedy in court if you need it, if it doesn't work out. But these tools are there outside of court to try to make it as easy, as painless, and as least emotionally straining as possible. The thing too with litigation, and I might be getting ahead here with the contested and the uncontested, is that when you go to mediation or you do a collaborative law process, there will be contested issues. That's why you're sitting there and trying to negotiate and trying to work through them. So you don't have to agree on everything. Both parties don't have to agree on everything to start the mediation process or the collaborative law process. I think if you have any questions regarding those two processes, please feel free to put in something in the Q&A. I don't know if Kate, do you want to talk about representation? What does it mean? Or do you want me to go into that?
I think you started. You want to continue what that was because you were talking about collaborative law and representation.
Okay. Yeah. So with collaborative law, as I said, you would have an attorney with you. You are being represented, even though the process for collaborative law is interest-based and the parties really talk things out with each other. It is guided by the attorneys, and parties are given advice by their attorneys. It's just like court, except you don't have someone standing before a judge arguing your case for you. But you do have the advocate in your corner, and you have someone guiding you throughout that process. For some matters and some cases, it's necessary, whether there be a power and control imbalance or whatever. Sometimes the situation calls to have someone in your corner in that meeting with you to facilitate things and get things done. But collaborative law is still driven by the parties and their interests and how they want to work things out. There's no motions, there's no things happening outside of that room regarding the matter. All issues are presented to each other, and they're worked out within that team. What's the right approach for you? It depends. It really depends. You could very well start off thinking litigation is the right approach for you, and then find out that through speaking with a divorce coach, perhaps, that there's emotions that need to be dealt with and issues, elephants in the room, should they say, that need to be addressed. And once those are addressed, you're more willing to sit down and mediate, which, as Kate alluded to, the court asks you if you want to go to mediation. They promote that. Sometimes they order it if certain situations are present, but the court, uses mediation as well as a means to come to a resolution. So the right approach for you, it just depends. If there's domestic violence, if there's any sort of power imbalance, maybe collaborative law is better than mediation. Maybe litigation would be. It just depends. Being open to all approaches and knowing that they're not mutually exclusive, that you can do one and utilize the other or change to the other at any time is really empowering, because you don't feel stuck with doing something that may not fit you or give you the peace you need to get through this difficult time in your life.
And can I just jump in there? I think it's really important to talk to an attorney who knows the different types, the different processes, because oftentimes people who just do litigation, you walk into their office, they're going to just immediately be thinking filing that joint petition. And it's not a one-size-fits-all approach. It really is what's the best thing for you. And you really need somebody who can educate you about the process options and help you make that decision, not be guided by a litigator who just only does litigation.
Yes, that's very true.
And then we're talking about litigation in terms of general timeline. So if you are in a litigated case, on average, to get to a resolution, which is usually the vast majority of cases settle at some point, to get to that point without a trial in New Hampshire, I would tell you on average could take a year, maybe a year and a half. If you have one of those cases that's highly contested and you end up with a trial, you could be looking at a lot more time than that.
Yes, and the general costs, Kate, if you don't mind.
Yeah, when you're in litigation, that's gonna be your most costly process. It's a question that I get asked all the time. It's not one that I can really answer. There's my hourly rate, and then there's the other attorney's hourly rate, and it's a question of how difficult is discovery going to be? How difficult is the other person going to make the entire case? How many times do you have to appear in court? It really just depends, and I unfortunately could not give an answer on that.
Yes, but in general, Kate, I think you would agree with me that mediation is significantly less money than any sort of long-term litigation.
Absolutely. Okay, so we went through some of this. I think now we wanted to get into more of the nuts and bolts of what actually has to be decided in order to get divorced. So at a high level, we look at financial support, division of assets, and then parenting. And then Lori and I will get into some of the other issues that people should be keeping in mind. With respect to alimony and child support, alimony is spousal support for a spouse who is in need. And in New Hampshire, it's based on a statute. That statute says that alimony is going to be 23% of the difference in the party's gross income. And it's usually paid for 50% of the length of the marriage. Separately, we have child support, which is for the support of the children, basic living expenses. And that's based on a formula based on both parties' incomes and how many children there are. And then it's going to spit out a number, and it's a presumption that number will apply. There is some interplay between alimony and child support. I'm not going to get into the nuts and bolts of it, but if it's a case where there is alimony is appropriate as well as child support, that's a little bit more nuanced. Child-related issues, so child support, child-related expenses in New Hampshire, children are considered emancipated at age 18, unless they're still in high school, and then it would be when they graduate from high school. If there is alimony, then you're going to hear words about a uniform alimony order, a UAO. There are multiple documents that need to be reached in order to get divorced in New Hampshire. So there's the UAO. Then for child support, that's a uniform support order, a USO. And then also we need to make sure we're identifying expenses that are being shared for the children. There might be daycare expenses or health insurance expenses, extracurricular activities. Just make sure you're identifying those and deciding how those are going to be shared between both of you. Then with respect to division of assets, New Hampshire is an equitable distribution state. Equitable does not mean equal, but generally the longer a marriage goes on, the more likely assets are going to be divided approximately equally. And when you are talking about the assets, the next document we want to talk about is something called a final decree. This is something that you need whether you have an uncontested or a contested divorce case. The final decree has a lot of information in there that needs to be reviewed. You can waive a final hearing so that you don't actually have to appear before a judge. So it is possible to go to mediation, have all these documents executed, and then file them with the court, and you never actually have to go to court. It's a fantastic thing in New Hampshire. Generally, that final decree, you're finally divorced about 30 days after the judge approves everything. And once you sign that, it's very difficult to make any changes to that property division in the final decree. It's basically set in stone. And then again, just make sure that you are working with your other professionals beyond just the legal team. So, if you are dividing a retirement account, that may need to be done by something called a qualified domestic relations order. Make sure that paperwork's getting processed, and that when you actually receive your portion of the retirement account, that you are setting that up with a financial advisor and investing that in the way that you want to be. And then with respect to any children that you might have, that last document that you're going to need is something called a parenting plan. In New Hampshire, we have decision-making responsibility. It's like legal custody, if you've heard that word, but the terms that we use is decision-making responsibility. It's a presumption that it's going to be joint decision-making responsibility. And then we have residential responsibility and parenting schedule. And earlier this year, we had a new statute that is suggesting that we have approximately equal parenting, which means greater than 40%. And I'm really seeing a big trend toward just being a 50-50 parenting time now in New Hampshire. If there is some reason why that would not be in a child's best interest, then there needs to be some findings to support that. This parenting plan will also contain information about holidays and birthdays, 3-day weekends, vacations. A lot of information goes into this document. It's very important to make sure it has everything that you want to have in it. Future modifications of the parenting plan can be difficult, and it's really just based on a statute. So, for instance, I also, as I mentioned, practiced in Massachusetts. In Massachusetts, you can seek a modification based on a material change in circumstance, which is really broad. It's not that way in New Hampshire, so you just need to make sure that you are taking into consideration that this may be a document that has long-lasting ramifications. I don't know if you want to add anything there about parenting plans, Lori.
Not about the parenting plan, but about the child support. Child support is a child's right, and I'm talking particularly with mediation. Some people come into mediation and they say, my spouse is going to give me the house, and I'm going to waive child support. Can't do that. It's because you can't bargain away the child's right to support. So during mediation, during collaborative law process, during even litigation, if a person wants to do that, they'll be advised on what the rules state, and if there needs to be a waiving from the child support guidelines, so to speak, as long as it can be justified and it falls within, as I said, the umbrella of what's acceptable, there may be a way to adjust the child support, but it has to be for good cause. It has to be justified. And that, I remember Kate was talking about alimony and child support, how there is, if they're together, there's some nuances to that, Kate, and correct me if I'm wrong, but that's where that would come in terms of wanting to adjust child support if with the alimony, the children's needs would be taken care of according to the law. Is that correct?
Yeah.
Correct. Yeah. So there are ways to adjust it, but it can't be bargained away. That's why talking to a divorce coach, having an attorney review your divorce, your mediation agreement, your separation agreement, will catch these things to make sure that that if there are adjustments to what the rules state or the calculator state, that it's justified and that it has a high likelihood of being accepted by the court.
And then other things that need to be addressed in these documents are things like medical insurance. They'll need to figure out who's maintaining medical insurance post-divorce, how those expenses are being shared. Life insurance, if people have a financial obligation following the divorce, so things like child support, alimony, child-related expenses, usually those are secured by life insurance. Legal fees, the general rule is that you're both responsible for your own legal fees. There can be assessments of legal fees if somebody takes very difficult litigation strategies, but in my experience, legal fees are very difficult to get in a divorce without expensive, protracted litigation. As I mentioned, child-related expenses need to be addressed as well. College. So as I mentioned earlier, children are considered emancipated at age 18 in New Hampshire, which means that a judge cannot order either party to contribute to a child's education. However, there is language in the final documents that you can voluntarily agree to contribute to college expenses. So if by agreement you agree, then you can finalize that paperwork. So that's one area where being in an out-of-court process like mediation or collaborative law can benefit you, because you can do more than what a judge can order. And then I think, Laura, you were going to go over the last couple ones. And if you had anything to add to what I just went over, feel free to jump in.
Yeah, just keeping in mind what Michelle had stated at the beginning of this presentation and what we have addressed throughout each of the slides, emotions are a big part of this process. There's no way to get around it. Whether you're litigating, whether you're doing collaborative law, whether you're doing mediation, there's going to be emotions. The key to a successful resolution where both parties are happy with the result. Now, and I'll get back to that in a moment, but the key to having that is to acknowledge and accept that these emotions exist and do everything you can to separate the two. Because if you make, as Michelle said, if you make decisions through emotions, or if you react through emotions, it's going to derail the progress of the negotiations and of getting everything settled. So they exist, but they are there. They shouldn't run the show. As Michelle said, if you're feeling anxious or if you want to react through the emotions, take a break. That may mean during mediation, stopping the mediation session for that day, going home, contacting your divorce coach, trying to work through those things to be able to have some clarity and to be able to be objective when you revisit those issues in the next session. And that's the beauty of mediation and collaborative law to a certain extent, is that it's on your timeline and things come up. And as Michelle said, you could be feeling several things at one time. You can be feeling out of nowhere fine, and then out of nowhere you feel a bubbling sense of grief or anger. And that's a normal, natural part of it. But it really does hinder the negotiation process and getting through the business portion of these negotiations, this legal process, because at the end of the day, you're dealing with assets, you're dealing with money, you're dealing with property, you're dealing with who's going to take care of your children. And so there needs to be a certain level of objectivity and ability to look at it outside of the emotions. So just don't suppress the emotions. I think that's the key takeaway to this. Embrace them, acknowledge them, but understand their place in this process. And as I said earlier, these processes, these methods are not mutually exclusive. They're all designed to help you get through this part of your life, this process, in the easiest, the least stressful way possible. And going into it knowing that neither party is going to get everything they want. If there's going to be any sort of negotiation or any sort of resolution, parties are going to have to understand that. But the key with the mediation and the collaborative law is to put those wants and positions on the table and have the parties talk through it and come to an agreement that each party can live with and they're okay with, even though they're not getting everything they want. With that being said, after the divorce, assuming everything goes well and everybody gets an agreement that they are comfortable with, once you get divorced, now you got to think about your own protection, your own peace of mind, your future. And that's where estate planning comes in. As I mentioned earlier, it's particularly important if you have a child who has a special need, whether that child is an adult or a minor. But also, when you're not married anymore, you have to you have to choose someone that will step in for you in the event of your incapacity, or if you can't take care of your own bills, or if you can't do things. And that's where estate planning comes in too, because estate planning does not only have to deal with assets or money, it has to do with your care. Naming someone in a trust that will take care of your bills or take care of your financials during an incapacity that you have is really key to rebuilding and protecting yourself moving forward. And also, let's say you get money from the divorce, you get a settlement from the house, you get a buyout from the house, or the house is sold and you have this money. Protecting that is very important. So it's the first step in this whole process is getting through the divorce process, and then it's rebuilding. So estate planning is a very crucial part of the divorce process, excuse me.
Thanks, Lori. So I think our next presenter is.
Yes. Good evening, everyone. So I'm the finance person, and I know that the topics are key legal considerations, but the finance part is actually one of the biggest decisions that you're going to make within the divorce. And I really appreciate Kate and Lori making a shout out to a team approach, because not all attorneys feel that way. And it's really great. And it's what really attracted me to Vesta is that team approach that we have. It may seem a little overwhelming when you are thinking about, we're hiring 3 sets of people. But really, honestly, so as the CDFA, what I can do is, instead of hiring 2 different attorneys collecting the same information as a neutral, then I collect it. So you don't have the duplicate of efforts. You also have people that are specializing in what their specific knowledge is. I'm not a legal expert, and the attorneys aren't financial experts. When you're hiring people of their expertise, I think it really is important to really look at it and build a solid bench. With the asset division, what we look at is really everything. We've listed it out, your real estate. Typically, what I see is you're going to have equity in a home and then retirement assets. So that's a pretty typical arrangement. I really try to encourage people, unless you have antiques or expensive boats, the cars should be on the asset division, but I really encourage people to try to negotiate the personal things and the furniture and leave that away to not pay experts to negotiate that. We also have your bank accounts where maybe you're on with your child. It all needs to be listed. Pensions, getting all that information. The key is really getting the information. And Kate and Lori mentioned in New Hampshire, we have the Rule 1.25a. All the states have a similar disclosure requirements where you have to produce a certain amount of documents, a certain history. It's anywhere from 1 to 2 years worth of history of bank statements, credit card statements. So it's quite a bit of the volume of information. If you're fairly comfortable and it's pretty friendly, you can also waive your right to some of the disclosure. I typically don't waive the right to it. I ask just for maybe less history if it's most of the assets are joint, but it's really important. Businesses, and again, your debts too. It's really important that all your debts come out on the table. And then when we look at it, I like to compare the apples to apples. Equity in a home is not the same as retirement assets. Retirement assets haven't been taxed. So how do we deal with that? We look at, how are we going to divide it? Because sometimes it isn't as easy as just taking a knife and cutting everything in half. That would make life easy, but it's not always that way. And things you have to be on the lookout for are, does your spouse get some type of deferred compensation? Do they have equity compensation, vested options, unvested options? That's really where maximizing your settlement is just really understanding all of the assets and liabilities. And it's not so much even understanding is important, but making sure we have everything. Get the tax returns. Even if you're contemplating a divorce, make sure you look at your past year's tax returns, and you can look on interest and dividend income. Are these accounts you recognize? Are these accounts that you're on? Look for retirement statements. Know the different companies maybe your spouse has worked for possibly for retirement assets. And then understanding what the specific things, the instruments are. A Roth IRA isn't the same as a traditional IRA. So I just had a case where they were paying their settlement out of a brokerage firm, and it was, I think let's say they bought 10 shares of Apple for $10, and now it's worth $500,000. So that's what my client's spouse wanted to give her to in lieu of cash settlement for alimony. She gave her this brokerage account, but it had a $490,000 gain in it, which that's not cash. So you really have to understand the assets exactly that you're being given. So are you getting a brokerage account that if you were to sell anything, you're going to have a significant tax liability? Are you paying out equity out of your house and getting retirement assets that someday you're going to have to pay taxes on? So that's really important and things that we look at. I think it's important also too, I always encourage my clients you're going to have your short-term needs, and it's really also important to look strategically, because let's say you're handed this lump sum of money, you're going to sell the house. Good plan isn't to use that cash from the sale of your house to fund, because your expenses are more than, let's say, the support that you're given. You really have to understand, is this sustainable to live on, and is this sustainable long term, or am I going to be chipping away at the assets that I have, and in 5 years I'm not going to have any assets? And also understand too the spousal and the child support. I think it was Lori mentioned that you can't give away your child support and negotiate away. You can negotiate your spousal support for an upfront payment if you're concerned about your husband or your wife might retire early or lose their job. Maybe you want to ask for spousal support and a lump sum settlement up front. Also, if you plan on getting remarried at some point, spousal support will end the minute you get remarried. Child support, it doesn't matter. So you just have to be mindful and strategic about what you're getting. But I think the main thing with child and spousal support is this enough money to live on. Now, it is difficult when you're now going to have two houses where you're used to lumping in that same amount. To a certain extent, I'm the financial grim reaper, because it is a bit of a reality check. And even if you have a lot, half of a lot is still half, and it's really tough. The main goal is setting yourself up for a sustainable situation. And in order to keep it sustainable, someone may have to go back to work, or you may have to downsize your house. But what you do is you need a sustainable situation. And then, of course, don't do anything. Don't go out and take luxurious vacations or run up your credit card bills. This could come back to haunt you in a way where you'll be responsible. And you also want to make sure you put things in place that if you have a joint credit card, you also want to make sure that your spouse doesn't do the same, and somehow then you become liable for this debt. You really want to make sure you keep tabs on anything that might have your name on it. Make sure that you're monitoring the accounts. And if you do feel like someone's draining an account, that's a time to step in and get some legal assistance to make sure that that's at least documented. And again, equitable is not always equal 50-50. So it's really important that you dig deep into exactly what you're getting, and you understand any tax or liquidity constraints that are going to be placed on assets that you have. And again, build a strong team. So that's my side. Now Renee is going to talk to you about the largest piece of most everyone's financial assets.
Thank you, Barb. Yes, last but not least, the marital home, the family home. It's generally one of the bigger, if not the biggest asset that you have. And we heard from Michelle talking about the emotional side of things. So yes, this absolutely is an emotional time. We have to decide, do we want to keep the house? Do we want to sell the house? Is one spouse going to stay in the house, right? These are all big decisions that have to be made. And so aside from the emotional side of it, we have to think about the financial aspects and what does that look like and what are our choices. And because this is one of your most valuable assets, we need to figure out what is the value and how do we do that. So we have a couple of options. You can have a CMA done. That is a comparative market analysis, and that's something that a realtor can do for you. We do have a realtor in this group. She couldn't make it tonight. Her name is Laura, and she's fabulous. She can give you all the details, what's happening in the market today, what we can expect in the market, and she can also give you an analysis for a potential value of your house, whether that's one spouse is keeping the house and we need a value attached to the home, or if we think we're going to sell the house close to divorce. And she can walk you through that process. The other option to value the home is with an appraisal. So an outside appraiser you can work with them to give you a value. It's going to be very similar to what a realtor does for you. Appraisers will look at past history. So what has sold in your area, similar homes, similar neighborhoods within a certain time frame. Whereas a realtor is also going to look at that, but they're also going to look at what's currently listed on the market and what do we think the market would bear if you were to sell the home. So similar, but a few nuances to them. So getting that value on the home is one of the first steps that you'll need, right? The whole idea of the divorce is to split. But we have to put a value on that asset in order to determine how it's going to be split. So one of the things that Laura would talk about is deferred maintenance. So deferred maintenance just means things in the house that maybe haven't been done yet, or have been put off. We all have those projects in our homes, right? But maybe we know the boiler is in its last years, or maybe we know the roof is in its last few years of its lifespan. And so you want to keep those in mind when you're valuing the asset. If you are either selling the house or you're the spouse that wants to keep the home, we need to understand what those maintenance types things are so that all assets aren't quite equal. You maybe have a house that's worth whatever, $300,000, but it has a roof that's going to need repair within the next year or two, and that could cost you $10,000. If you're selling the home, that could come into play where perhaps the sale price of the home might be reduced because of some of those deferred maintenance items. So Laura, our realtor in the group, again, she can talk to you about what does it make sense to repair before we sell the house, and what does it make sense not to repair, that it wouldn't have much value given to it in a sale situation. But if you are the spouse that is wanting to keep the home, you'll need to be mindful that, any of those deferred maintenance items, you're going to be responsible for going forward. So if you're keeping the house, all of the maintenance, all of the taxes, the insurance, the upkeep, all of that's going to be for you to handle. And so if you're going into the divorce settlement knowing that you want to keep the home, just be mindful of those deferred maintenance items. So if we're keeping the home, you want to find out, can you afford it? Right? So there's a couple of pieces to that. So there's the mortgage side of it. Do you qualify for the mortgage? If both of you are on the mortgage, you need to determine if you're the spouse wanting to keep the home, likely the out spouse or the spouse departing the home is going to want to be removed from that mortgage. And so you need to know if you qualify from a lender's perspective, if you qualify for that mortgage. So talking with a lender early is super, super important. If you're going to spend the money on an attorney or a mediator or collaborative law, whichever avenue you're taking, you want to make sure that they're negotiating for you for something that will actually work financially from a lender's perspective for you. So buying out a spouse, right? That's all part of understanding all of the numbers. If there is an equity split and there's equity in the home, and now we've had an appraisal done or a CMA done, and we know what the value is, we know how much equity is in the house, and the spouse leaving it is going to need that equity. Now, it can come from other assets. You may negotiate to take one asset over another. But if there is a buyout and you're using the mortgage for that purpose, you'll need to make sure that you qualify for that mortgage. And then capital gains. That's something I know it's been mentioned a couple of times tonight. If you're the spouse wanting to keep the house, be mindful that down the road, if you're the one selling the property, then you're going to be the one responsible for those gains. So again, talking with your lender, and I do recommend a CDLP, that's a certified divorce lending professional, because we have the experience. We deal in divorce every day and we understand the nuances of it. So selling your house, if you, again, have a market analysis and your realtor can tell you what you could list the home for, they can also tell you about the market timing and when is it best to list the home. So all of these things will come into play as you're negotiating the divorce and the timeframes. And once all of this has to be put into the final settlement agreement. And so everyone needs to be on the same page. We're going to sell the house. Maybe we're selling it before the divorce is finalized. If it's going to be afterwards, based on timing in the market, and is it better to sell it in the spring or is it better to sell it in September? Whatever that time frame looks like, your realtor can help you with that. And you want to allow enough time to sell it post-divorce. If that's when you choose to sell it, make sure you give yourselves enough time in the settlement agreement to not only pack the home and manage that aspect, but where will you be going? So your post-divorce living really comes into play. We can't sell the house, or one spouse is keeping the house until we know where we're going to live post-divorce. So those things all need to come into play. Next slide, please, Kate. So mortgages and divorce. So a couple of legal strategies that I wanted to touch base with you tonight. So some settlement language in the final settlement agreement. So there's wording matters. So lenders rely on the exact language in the divorce decree. So if it's vague or poorly drafted, sometimes the lender, they won't interpret. They will just say, no, we can't use it. So again, talking with your CDLP early to make sure we can collaborate with your attorney, with your financial advisor, with your mediator, so that the outcome that you're looking for as it pertains to your home and your mortgage, we want to make sure it's written up correctly so that it is, we tell people, if even though something might be a lending option, if it's a legal option, it may not necessarily be a lending option. So we want to make sure that both are coinciding. So we have to be very explicit in the divorce settlement with dates and timeframes and understanding that process. And then including any contingencies, right? So if your settlement says we're going to sell the house and we're going to sell it by X date, it has to be very specific and very clear. And how are those proceeds going to be split? And until the house is sold, who's going to pay the mortgage? Who's going to do the maintenance? Who's going to pay the taxes? So all of those things need to be addressed. And then the equity buyout, again, we're going to base the value of that asset depending if you've had a CMA done or an appraisal done. When you refinance the mortgage, the lender does their own appraisal, and you want to make sure that there's something in there. If you've had the house appraised for $300,000 and the mortgage lender does the appraisal and the appraisal comes in at $290,000, now you have a problem. All of your numbers that are in your final settlement are based on that $300,000 appraisal that you had done. And now the lender has come up with a shorter, lesser number. So all of these things need to be addressed, all of these contingencies in your final settlement. Debt allocation. So again, the wording in your final settlement, just because your legal document, divorce settlement agreement says that the joint credit card has been assigned to spouse A, and they're responsible for making those payments. That doesn't remove spouse B if it's a joint card, just because the legal divorce settlement says spouse A is responsible for it. From the credit card company's perspective, you're both on that card, you're both responsible for it. So those are some of the things excuse me, we can assign the debt to somebody, but that doesn't necessarily remove the liability from the other party. And then the support income and mortgage qualifications. So whether it's child support or alimony, those need to be spelled out correctly in the settlement agreement. So there's some rules around support and whether a lender can use that as income to qualify you for a mortgage. And again, we want to make sure the duration of the support is spelled out. We want to make sure the frequency of it and the payment method, all of these make a difference. Again, if a lender has to use the final settlement agreement, if you're using support to qualify, we have to see the final settlement. And if there's any question in there and the lender can't make heads or tails about what your support's going to be, they will say no, and they won't allow us to use it. So again, talking with your lender early to understand exactly how it needs to be written up. Most attorneys are fairly good at it, but you want to make sure that it's written in a way that is a lending option for you. Sequence of timing of everything. So when we talk about a buyout to a spouse and we talk about the timing of when that's going to happen and the transfer of ownership of the home. So in most cases, both spouses might be on the mortgage and both spouses are on the title. And so generally, we will see the timing of the removal of one spouse from the ownership of the home or the title to the property at the same time that they're giving their buyout. Again, as long as it's written up correctly in the divorce settlement, from a lender's perspective, it's gonna happen at the same time. It's simultaneous at your closing for your mortgage, and we're using the mortgage as to get cash for the buyout to the departing spouse. We're going to have the departing spouse sign the quitclaim deed at the same time. So timing and it all happens at the same time. Let's see here. A couple of last points. So coordinating the legal and the financial and the lending strategies. So I mentioned we can collaborate with your whole team, and that team approach just makes it that much easier to get through the process. Most of us will work jointly with each other to get through that. And that's pretty much it that I wanted to cover tonight. I'm going to invite the rest of the team back. The concierge will be reaching out to everybody in the next couple of days for anybody that attended tonight. If you have any questions, if there's any of the panelists that you would like to meet with, I think most of us offer free consultations to have those conversations to start out and see how we can help you. But do feel free, if you do have questions, you can reach out directly to the concierge. You met her tonight, Mandy. All of her contact information is on the website. So with that, I will wish everybody a good night and thank you for joining us.
Thanks everyone for joining. Good night.
Good night.